they say you can trust us. Oh, but they use a badge for an illusion of justice. Oh, they say you can trust us. Oh, but they use the flag for an illusion of justice.
How you doing, everybody? We're here today talking about ineffective assistance of counsel, talking about the motion for post-conviction relief. This is part 2 of ineffective assistance of counsel. Those of you who haven't seen part 1, you might go down to the description section there, and I'll have the link for part 1 there if you want to go watch that one real quick. Anyways, so this is part 2. Because the ineffective assistance of counsel section was a rather large section of the motion for post-conviction relief, we had to break it up into 2 videos because we didn't want you guys having your eyes rolling into the back of your head as we went into over an hour of just legal stuff over and over. So we split it up into 2 videos to make it a little more digestible. And so that's what we're going through today. Ineffective assistance of counsel, part 2. Here we go. Next slide. Okay, remember, we have a kind of a framework here. We do the slideshows first, and then we do a live that will follow it. Pretty sure we're going to be doing that live session tonight following the premiere of this video. So keep your eyes open for that. But also, while you're watching this, remember to save your question and note the slide and even the paragraph number that your question pertains to. Note those so that during the live event, you can tell us that that's what your question was in reference to, and it will help us to better answer your questions. So, like I said, remember to note the slide and paragraph number when you have a question. Next slide, please. Okay, and picking up basically where we left off last night, applicable case law regarding state's coercion of the witness to provide false trial testimony. A prosecutor's knowing use of false or incredible evidence to obtain a conviction violates a defendant's right to due process guaranteed by the 14th Amendment to the United States Constitution. State v. Nerison. On occasion, it may be discovered that the prosecution's case rests on perjured testimony that the prosecution knew or should have known was perjured. The state violates a defendant's due process rights to a fair trial by using and failing to correct false testimony. The crux of a denial of due process is deliberate deception. Sounds a lot like what they're doing with the bones right now. Anyways.
Yeah.
For example, what? Go ahead.
Well, so there's a few things where she's going with this. So the testimony of Bobby, for example. Now with the computer data, we know that his timeline when he was asleep, when he woke up, when he left, may not be accurate. We know from a phone call that testimony may not be accurate. It can also be, doesn't have to be a lay witness, it can be an expert witness that they know is given false testimony. And right. So this is going to come up over and over and over again with, she's going to show that by not retaining their own experts, they weren't able to detect deceit and dishonesty from Kathleen's perspective in the expert testimony presented at trial. So if you don't have an expert to say, hey, wait a minute, that's below the standard of care, that's absolutely false. You can't burn a body in that amount of time, for example. Everybody knows that's in this business. If you don't have an expert, like the experts that Kathleen's hired, then you can't determine that there's provable false trial testimony.
Right. Yep, absolutely. All righty. So Paragraph 192. For example, in State v. Whiting, one state witness testified to a sequence of events that contradicted the testimony of other states' witnesses. The defendant argued that the witness obviously lied, and as a result, the state presented false testimony, which violated the defendant's due process rights. The court disagreed, finding the state's use of the witness testimony proper because it was the jury's role to determine the truth of the witness's testimony. Any thoughts on that, Trav? How fun it is pitching a case to a jury?
Yeah, you know, it's attorneys in closing argument are given license to argue what the facts mean. You know, you're basically connecting the dots. Mm-hmm. What came in through the testimony from the witness stand, the trial exhibits, and what's stipulated. And but you are not allowed to invent a false narrative that isn't supported by the facts. And we keep coming back to this. That's why Kathleen is always trying to show, whether it's ineffective assistance of counsel, which is the section and we're now in now, or something else, is that you're trying to undermine confidence in the verdict.
Right.
And if you can show that the state's narrative was false or misleading, that's one of the ways you can undermine confidence in the verdict.
Right. Okay. Next slide, please. Okay. Unlike the defendant in Whiting, Mr. Avery is not arguing that he was convicted because of a state witness that contradicted the testimony of other witnesses. Mr. Fabian's testimony that he observed heavy smoke and smelled burning plastic, presumably of Miss Halbach's burning electronic components, has been completely refuted by a simple experiment. Therefore, Mr. Avery has established a due process violation occurred because he has established that there was false testimony, the state knew or should have known it was false, and there is a likelihood that the false testimony affected the judgment of the jury. Mr. Avery must be granted relief because implicit in any dignified concept of due process and well-rooted in American jurisprudence stands the principle that a conviction obtained through the use of false evidence or testimony known by representatives of the prosecution must be set aside in favor of a new trial. Next slide, please. Okay, applicable case law regarding admissibility of expert testimony on police practices and investigations. Paragraph 196, in Jimenez versus the City of Chicago, the Seventh Circuit Court held that expert testimony on police practices and investigations is admissible. The plaintiff's expert in that case, Mr. McCrary, testified in detail as to reasonable practices for police investigations and how investigation of the underlying murder in that case departed from those practices. Mr. McCrary is the expert on investigations in Stevens' case as well, by the way, folks. The defendants in Jimenez argued that McCrary should not have been permitted to testify regarding reasonable police practices because reasonableness is a legal conclusion, and experts are not permitted to provide legal opinions. The defendants also argued that Mr. McCrary's testimony amounted to an impermissible attack on the credibility of the other witnesses. The Seventh Circuit disagreed, explaining that Mr. McCrary's testimony permitted the jury to infer that the investigators had engaged in deliberate wrongdoing. The Seventh Circuit further noted that Federal Rule of Evidence 702 permits an expert to testify regarding his opinion if the expert's scientific, technical, or otherwise specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue, but a witness may not offer legal opinions. Any thoughts on any of that there, Travis?
Yeah, so that's always the dilemma. You know, these cases she cites, they're civil cases, 1983 civil rights cases, where basically a battle of the experts. Did the police follow normal, regular procedures? But it carries over into the criminal law because what showing through Mr. McCrary, and you're way more up on the facts of it than I am, and you had your own retired FBI agent on one of your shows, but
right.
trying to show, that they use confirmatory bias to reach these conclusions, and that when you have confirmatory bias involved in an investigation, you don't even have to have an evil motive or intent. You're going to get to the wrong conclusion 95% of the time. And the 5% of the time, what did your FBI agent said that, when you have poor investigation.
Yeah, he said a bad investigation doesn't necessarily mean you got the wrong guy or that they got the wrong guy. He said, but if they got the right guy, it's more luck than anything.
Right. So it's, 95% of the time you're going to end up with the wrong or a bad conclusion because of the confirmatory bias. I guess about 5% of the time you just luck out, and you end up going on a hunch and getting a guy convicted based on a hunch and all of these confirmatory things. But she's pointed out that this is legitimate evidence admissible at trial, and therefore it's another example of not having an expert to let the jury know. All the jury heard is, Wiegert and Fassbender. This is how we do it. This is I've been doing this for 30 years, or I've been doing this for 20 years. But if you were taught improperly, or you've been doing it wrong, or you're just outright evil and sinister, and you violate the law,
Right.
That doesn't make it the right way. And that, by having somebody who is an expert in investigations like Mr. McCrary, they would have been able to point out to the jury whether something is just incompetence, for example, or that they're engaged in deliberate wrongdoing.
Yeah. I like the other thing that G-Man Moore said about McCrary. He said if McCrary thinks, if McCrary said it, he goes, I'm inclined to agree with him. He goes, I know McCrary's not for sale. He was like, oof. He said that in the video. It was like, so, I mean, he has a tremendous amount of respect for McCrary. So, for what that's worth. Next slide, please. Okay, Mr. McCrary testified about the steps a reasonable police investigator would have taken to solve the murder at issue, as well as the information that a reasonable police investigator would have taken into account as the investigation progressed. He did not try to resolve conflicts in the testimony. For example, Mr. McCrary noted that one witness had given an investigator two inconsistent versions of the events of two different times in the investigation. In such an instance, Mr. McCrary explained, a reasonable officer would have realized that both of the stories could not be true and would have tried to resolve the conflicts. Importantly, Mr. McCrary's opinions did have direct implications for applying legal standards such as probable cause and whether or not Brady v. Maryland was violated, but those implications did not make his opinions inadmissible. They made Mr. McCrary's testimony relevant.
Right. So what they're saying there is Mr. McCrary cannot get on the stand and say, in my opinion, they violated Brady v. Maryland. They violated Youngblood. They violated the 14th Amendment. They violated the evidence preservation statute. Those are legal opinions, right. Purely legal opinions, and that testimony would not be admissible. Right. She's pointing out, though, that he would be able to provide relevant admissible testimony as to where the investigation was deficient, what could have been done to resolve conflicts, what conflicts were present, what deficiencies were present, and that is relevant admissible testimony. You can go all the way up to, well, yeah, that should have been turned over. At the FBI, our policy would have been to turn that over. When you had your person
Yeah.
on, they
Seymour Manmore, when he
he
talked about
constantly was saying
meeting the criteria for the district attorney, the U.S.
Yeah.
district attorney, I was like, wow, like it seems like everybody should be like that.
Right. Yeah. How many times did he say in that video, we would not have been allowed to do this,
Right.
where I was. We would not have been allowed to do this. We would have turned over that.
Right.
On and on and on. I would have had to have called up and gotten permission,
right,
to use. I don't know if it was the Riley technique on the Reed technique on a juvenile, but he said would have to call and get permission to do what just came automatic to the investigators in this case.
Exactly. Yeah, and he also said that little area of Wisconsin. He said it's one of the worst areas, in his opinion, in the United States when it comes to criminal justice there. He said because the judges are loose and they let the prosecutors get away with a lot. And because they let the prosecutors get away with a lot, it rolls downhill, and the prosecutors let the law enforcement get away with a lot. And then suddenly you just have a culture of corruption, because there's nobody there trying to be the voice of reason and rein it in at all. And he was just basically saying it all starts with the judges there, and the judges are not, being strict enough on these prosecutors, and therefore the prosecutors are not feeling the need to be strict on, the orders they give law enforcement, whatever. So,
let me just add one quick thing in there. At certain times in your episodes, you ask, why people are here, and we'll get into that in later episodes and maybe talk more about that. But people should be keeping that in mind on this topic. And I'm not going to get into politics on this; it has nothing to do with it. But you bring up a very good point, that it's because of the judges. Well, in Wisconsin, like Texas and California and a lot of other states, who the governor may appoint these people initially, but who keeps them in their job? It's the voters. Right. And so, and again, not getting political on this at all. It's up
to the people in an area to take charge, though.
Yeah, and it's up to people sometimes within a state or outside of a state or a higher court like the Supreme Court, to make people aware that you can be doing better, to make people aware that your complacency is starting to cost you. And so awareness, a movement, sometimes is what it takes to right this type of injustice. Because if the voters don't care, this is what you end up with.
Right.
We see this over and over and over again, all over the country.
Yeah. Well, that's what he said. Because I even said, God, why aren't more people like the district attorney, the U.S. district attorney? I go, all over the U.S. And he kind of goes, well, he goes, a lot of places are, and I immediately was like, I felt like egg on my face, I'm sorry. Obviously, there are probably a lot of places that have a very high standard. He goes, that's when he started talking about, it's that particular area of Wisconsin. It's when he started talking about that particular area of Wisconsin and stuff. So, anyway, so moving to the next slide. Thank you, Miss Lovely Julie J on the working the slideshow tonight, by the way, people. So, big hand for Julie J. Okay, so failure of the trial defense counsel to present a police procedure and investigations expert to demonstrate that the police investigation was fatally flawed in numerous ways. Current post-conviction counsel's police procedure and investigations expert, Mr. McCrary, has over 45 years of experience in law enforcement, including 25 years as an FBI agent. While in the FBI, Mr. McCrary spent 17 years as a field agent until he was promoted to the National Center for the Analysis of Violent Crime Behavioral Science Unit, where he used his expertise in investigative techniques and crime scene analysis in violent crime investigations to assist both FBI and other agency investigations. Next slide, please. Significantly, Mr. Avery's trial defense counsel failed to obtain an expert in police procedures and investigations such as Mr. McCrary, who could have educated the jury about the fundamental failures of the investigation of the homicide of Miss Halbach. Law enforcement failed to study the lifestyle and relevant history shared by Miss Halbach and those close to her. Law enforcement failed to begin their investigation with a credible investigation of those closest to Miss Halbach. Law enforcement failed to identify which witnesses intentionally misled the investigation. Law enforcement's investigation of the homicide of Miss Halbach failed when they constructed a flawed narrative of the crime and built organizational momentum toward the resolution of the flawed narrative. Law enforcement's investigation was characteristic of tunnel vision and premature closure when they closed the investigation to alternative theories, and law enforcement's investigation was characteristic of confirmation bias, anchor bias, and groupthink when they failed to consider suspects other than Mr. Avery.
So a couple of those, your crew would be able to tell you, when they, in some of those sub-paragraphs, failed to look at people close to Teresa Halbach. So
victimology. That's a big part of his thing. So victimology.
And
we know. By the way, Julie, just a little bit. Sorry. Go ahead, Travis.
But so we're looking at people close, so we know who he's talking about there and who she's talking about there.
Thank you, Julie.
You can look at those, and then reading between the lines, we're talking about the people that were close to her, and we know who those people are. She's mentioned them in her briefs all along, who her DENNY suspects are. And
so when it says built the flawed narrative of the crime and built organizational momentum toward the resolution of that flawed narrative, is that organizational momentum the coercion and press conference with Dassey?
Yeah, it's a mob mentality. It's ignoring what you know to be best practices and good police investigations, that you never make any assumptions, you pursue all leads, you remain objective. If you start to get too emotionally involved in the case, or if you're already emotionally involved in the case because you're a close a friend of the family or something, you say, I need to bring somebody else into this who could be more objective if we really want to catch the right person. And they're also talking about it can be the most heinous types of things. It can be a racial prejudice. It can be, other types of prejudice. It can be, the person's the wrong color, they're the wrong ethnicity. It could be that. It can be when you have an elected official like a sheriff that's under a tremendous amount of pressure to make an arrest. It could be monetary considerations to save money, so you take shortcuts, or if you've got a big giant civil suit looming out there, that this may be a fortuitous thing, but all of that fits into that. But even without a pending civil suit and whatnot, if you're a small town department, you've got a lot of pressure, and the voters can oust you at any time. They become pressured to make a quick arrest and do things that in hindsight they wouldn't have done. But that is organizational. And here's the best example of where is it? What's the exact quote? Organizational momentum
toward the resolution of that flawed narrative.
All right. So who is the former sheriff that testified at the hearing that Peterson that no, I'm not convinced that the DNA from Allen.
Oh, that's Kush.
I'm not 100% convinced.
Where did the DNA come from?
That we didn't get the right guy. That was Peterson, wasn't it?
I don't know. They all made such ridiculous statements about that.
Well, that hearing after even Judge Willis heard that testimony, I'm pretty sure it was Peterson. Either that or it was Kasurik, one or the other. Mm-hmm. That's when he said, no, I'm not going to let these local deputies handle this jury and handle the trial. We're going to move this from Manitowoc County to Calumet County, and we're going to try it in Calumet County because this is not a good thing, having former sheriffs getting up here and testifying that, you have a man exonerated conclusively with DNA, mm-hmm. saying, nope, I think we still did get the right guy.
Right.
That is organizational momentum.
Yeah, definitely. All right, so now next slide, Julie, please. Thank you. Okay, Mr. McCrary holds all the following opinions to a reasonable degree of professional certainty in the fields of police practices and investigative procedures. By the way, folks, Mr. McCrary was chosen, of all the FBI agents, he was chosen to go over to Sweden to help them set up the Swedish FBI, the Swedish Federal Bureau of Investigation. This was the guy that was chosen to do that. So just to let you know how top-notch and well-respected this guy is in his field of investigations, that should give you some clue. Every meaningful investigation or analysis begins with a study of the victim. That's victimology. For example, investigators must seek to identify who the victim was and what was going on in his or her life at the time of the event when initiating a death investigation. According to the FBI Uniform Crime Report, most victims of homicide are killed by someone known to them. Further, the motive to kill typically is rooted in interpersonal conflict between the victim and the offender. While shifting prematurely from an evidence-based investigation to a suspect-based investigation is problematic, investigators should be sensitive to signs and behaviors when developing or prioritizing suspects. The more organized an offender is, the more likely he or she is to inject themselves into the investigation in an attempt to exert as much control possible over the situation or over the investigation. And they're talking about Ryan Hillegas right there, folks. Next slide, please. Okay, from the first exposure to a crime scene, investigators construct a narrative of the crime that is derived from the chaos of the crime scene and the mindsets of individual investigators. Once investigators have constructed the narrative for a crime, their conception fundamentally alters how they perceive and incorporate evidence introduced through their investigation, such that their objectivity is compromised. The resulting investigation becomes an exercise in validating the dominant hypothesis rather than objective evaluation of the evidence. Cognitive biases such as confirmation bias, anchor traps, organizational momentum, and groupthink commonly cause investigators to make avoidable mistakes and jeopardize the successful resolution of their investigation. Next slide, please.
So while we're going to the next slide, remember that thing over the radio they showed in MAM1, it may have been in 2 also, but there's radio chatter, and they're showing it during the thing, and they call it, yeah, we've got our car, it's at Avery Salvage Yard. And remember what the response was over the radio?
Right.
Do we have them in custody yet?
Right.
That is organizational momentum,
yeah.
Anchor traps, groupthink.
Right. Okay. Absolutely. Okay, so tunnel vision emerges when investigators unduly limit the alternatives to their fixed hypothesis, such that the other suspects who should be investigated are eliminated from the investigation, and evidence that cuts contrary to the dominant narrative is discounted or ignored, and even destroyed before trial sometimes. Scott Davis. Anyway, similarly, premature closure results when investigators make early judgments about the resolution of their investigation and defend those judgments tenaciously, even in the face of conflicting evidence. Confirmation bias is a type of selective thinking in which an individual is more likely to notice or search for evidence that confirms his or her hypothesis while ignoring or refusing to search for contradicting evidence. Regardless of what seemingly valid alibis are offered, potential suspects should be examined for injuries when investigators believe that a violent crime has occurred. Injuries are best considered to be transient evidence, and if they are not documented early in an investigation, they will be lost.
Okay, so before we go to the next slide, so 213, we're talking about photographs of somebody's hands. Who would that be?
Right.
And somebody's back. And somebody's back. 211, let me read you one quote that Kathleen thought pertinent. This is from the affidavit of Greg McCrary, and I'm quoting: "Arresting the first likely suspect and closing the investigation off to alternative theories is a recipe for disaster. Tunnel vision has been identified as a leading cause of wrongful convictions." End quote.
Yep.
I think that, sums up what you've been talking about last, couple of 3 slides.
Right.
Very important.
Yeah, certainly. Okay, so next slide, Julie, please. Okay. Failure of law enforcement to investigate Miss Halbach's background to realize that she was at an elevated risk of becoming a victim of violence. Miss Halbach, the victim in this case, could be considered to be at an elevated risk for becoming the victim of violence due to her prior abusive relationship with her ex-boyfriend, Mr. Hillegas, and her business, which involved nude photography. Failure of law enforcement to identify prior abuse in Miss Halbach's romantic relationships to correctly assess the motive for her murder. According to Mr. McCrary, based upon the violent crime statistics, the killer most likely knew Miss Halbach and may have been involved at some point in time in a romantic relationship with her. Before Miss Halbach's murder, the killer most likely became aware that she was sexually involved with a married man and a second male who was a very close friend of the killer's. Next slide, please. Mr. McCrary is talking about Ryan Hillegas right there, by the way. The killer's post-mortem activities to conceal evidence and frame Mr. Avery. The killer wanted as much time as possible before the people close to Miss Halbach realized she was gone. As she received more and more phone calls, her voice mailbox became full, something uncharacteristic of Miss Halbach. The killer, who knew the password to her voice mailbox, deleted several of Miss Halbach's voice messages to buy himself time before Teresa's family and friends realized she was missing and began searching for her. Before her death, Miss Halbach was known to regularly check and respond to her voicemails. The method of deletion, in order to leave no record in Miss Halbach's cell phone records, could only be accomplished in one way. Her voicemail had to be accessed from another phone by using Miss Halbach's voicemail password. Miss Halbach's phone records do not indicate that her voicemail was accessed using her own phone after 2:12 p.m. on October 31st, 2005. Next slide. Knowing that he was likely to be a prime suspect due to his prior romantic relationship with Miss Halbach, the killer, who was highly organized, devised a plan to burn the body and plant evidence which would focus law enforcement on someone else. Because the killer found appointment details in the paperwork in the RAV4, he knew Miss Halbach had an appointment with Mr. Avery earlier that afternoon. The killer wanted to control the investigation and direct it towards the single goal of framing Mr. Avery for the murder. To accomplish that goal, he volunteered to take control of the citizen search as a means of both staying informed and controlling the focus of the investigation. The killer participated in the discovery of major pieces of evidence, even going as far as leading searches to the vehicle that he planted. Next slide, please. Okay, the killer, and not law enforcement, planted Mr. Avery's blood in the RAV4. The only parties who have had motive to plant evidence inculpating Mr. Avery were the killer and law enforcement, namely MCSD, Manitowoc County Sheriff's Department, in light of Mr. Avery's pending civil action against Manitowoc County. However, current post-conviction counsel has determined that MCSD officers did not have time to plant Mr. Avery's blood in the RAV4 on November 3rd of 2005. After Sergeant Colborn came to the Avery property on November 3rd to speak with Mr. Avery around 7 p.m., he attended a meeting at the MCSD at 8 p.m., so didn't have time. The killer was familiar with the Redont and the Manitowoc County pits. He devised a plan to bring the RAV4 from the murder scene to the Avery property. His chief objective was to plant the vehicle on the Avery property. Once Mr. Avery departed, the killer began to drive the RAV4 onto the Avery property. When Mr. Avery spotted the RAV4's taillights and turned around and drove back to check it out, the killer retreated to Cuss Road. Next slide. On November 3rd, the killer learned vital information from law enforcement during his police interview. He quickly realized that law enforcement was focused on Mr. Avery and not him. On November 4th, the killer decided to make another attempt to plant the vehicle on the opposite side of the Avery property. That is, in the southeast corner, close to the crusher. The killer, who drove the RAV4 into the Redont pit in the late afternoon of November 4, was aided by an accomplice who drove another vehicle into the Redont pit to give the killer a ride out after the killer planted Miss Halbach's vehicle on the Avery property. And you guys will remember the story of the guy who saw a RAV4 looking vehicle and a white Jeep go past his house towards the basically the entrance into the back of Avery Salvage, and that later on he saw just a white Jeep come back. So that's kind of what that's all about in a sense. The killer led law enforcement to Miss Halbach's vehicle later in the evening on November 4th. The killer represented to law enforcement that he would be willing to search the Avery property, something that the police could only do with a warrant based on probable cause, which they did not have on November 4th. Once the vehicle was found on the Avery property, the investigation of any other potential suspects halted, and just as the killer claimed, the whole case was focused on Mr. Avery, or planned, sorry. Anyways, next slide, please. The killer planted the bones and the electronic devices. As the leader of the search team, the killer had unrestricted access to the Avery salvage yard and the surrounding properties, closed off to public access. This was critical because the killer still was in possession of the burned bones and the electronic devices of Miss Halbach. The killer knocked out the RAV4 parking light while trying to plant the RAV4 on Mr. Avery's property. Mr. Avery did not see any front-end damage to Miss Halbach's vehicle when she came into his property on October 31st, 2005. Mr. Schmitz, an earlier appointment of Miss Halbach's, noted that Miss Halbach's vehicle looked very new and did not note any damage. Only someone who committed the murder or was involved in the effort to plant the vehicle on the Avery property would know the significance of the broken parking light and that it had been placed in the RAV4 to conceal the fact that the vehicle was moved onto Avery's property from elsewhere. Northwest of Mr. Avery's trailer, between the Avery property and the cul-de-sac of Cuss Road, there was a metal post protruding approximately 2.5 feet from the ground. Next slide. Only one person meets the requirements of DENNY as a third-party suspect with motive, opportunity, and a connection to the crime. Now, I will say, this was the first thing she filed. She's saying one right now, but really, I think even at this time, she was still thinking Redont to a certain extent. But anyway, the one person is Ryan at this point, but those of you who have been following, you know she has now included Scott and Bobby. So, Mr. Hillegas was Miss Halbach's ex-boyfriend. Mr. Hillegas and Miss Halbach knew each other since they were freshmen in high school and dated on and off for 5 years. Although Miss Halbach and Mr. Hillegas were romantically involved during their high school and college years, they were no longer together in 2005. Although Miss Halbach reported to friends that Mr. Hillegas continued to check her out despite being broken up for years. And in fact, I guess he used to annoy the heck out of her by coming over whenever he wanted. And then, you know, like she just kind of ended up feeling a bit like smothered by him, I guess, from some of the reports I read. According to Mr. Pierce, a friend and colleague of Miss Halbach, he's basically her mentor, Miss Halbach had been in a verbally and physically abusive relationship prior to or during her internship with Mr. Pierce. Miss Halbach interned with Mr. Pierce in 2003 during her senior year of college when she was still involved with Mr. Hillegas.
Okay, so, you know, this is a really good point to part, you know, why are we going through all of this? And, you know, this motion is over a year old, but this is what's being appealed. And when she files her brief, this is what it's going to cover. But, and we're going to be doing a segment on this, there are things that got filed after the motion for post-conviction relief, like the supplemental motions about the computer records, for example.
Right.
So, yeah, we saw by this time she had pretty much eliminated Redaunt. It was Redaunt and Ryan in the motion for post-conviction testing. She laid out suspect 1, suspect 2, right, which you, if you knew the case, you could infer were Redaunt and Ryan.
Right. Now
we're in, you know, summer of 2017, and she's narrowed it down to Ryan, pretty much eliminated Redaunt. And then we're going to see over time that by the time all of these motions get decided, she's also added and has a pretty good theory about Bobby and Scott. But that's why we're looking at this, because when she does file the brief, we're going to be able to look at that and go, okay, this is how it's evolved further, or this is how it's changed. And this is not unusual whatsoever, because she's conducting her own investigation, mm-hmm, and she's utilizing her own experts to analyze everything. And it takes time to look at everything, and it evolves over time.
Right. Absolutely. All right. Next slide. Okay. Jealousy was the motive. While Mr. Hillegas maintained an interest in Miss Halbach, she was no longer romantically interested in him. Miss Halbach became sexually involved with her housemate, Mr. Blodorn, in the months preceding her disappearance. Mr. Blodorn refused to sit for an interview with Mr. Stephen Kirby, but when he was told that the current post-conviction counsel planned to name a suspect in Miss Halbach's murder, Mr. Blodorn immediately blurted out, "You mean Ryan Hillegas?" Yeah. So, Mr. Scheck left a text message for Miss Halbach at 12:45 p.m. on October 31st, 2005. Mr. Scheck was completely forthcoming in his interview with law enforcement on November 4th of 2005 that he had texted Miss Halbach. He was not asked the content of the message nor to show the message to law enforcement during his interview. For some unknown reason, Mr. Hillegas called Mr. Scheck on November 3rd, 2005. According to their phone records, this was the first time Mr. Hillegas talked to Mr. Scheck on the phone. So, the important thing there, folks, is it's drawing a connection between the jealous ex-boyfriend and the current husband in a couple of, who is basically the guy that Teresa is currently involved with. So you can understand that this is a volatile situation that is brewing, right? So, okay, moving on. Next slide, please. Mr. Hillegas, a.k.a. Kilgus, intentionally misled investigators. When Mr. Hillegas volunteered false information about when the parking light damage occurred, it raised red flags about his involvement in the murder and an effort to frame Mr. Avery. For those of you who don't know, he tried to tell Tom Fassbender that Teresa had filed a claim on the damaged light on the front of the RAV4, that she had received a lump sum and had just not gotten it fixed. It was a lie. Kathleen Zellner went and found there was never any claim made. We all know now that the state is asking Mike Halbach to go digging through all of his old computers in the desperate hope and a prayer that he's going to find some proof of the damage. Anyways, moving on. Mr. Hillegas intentionally diverted investigators by reporting that the damage to the driver's side bumper and parking lights of Ms. Halbach's RAV4 occurred months before her disappearance and that she had filed an insurance claim for the damage. Mr. Hillegas was trained as a nurse, but was unemployed in October and November of 2005. He had no alibi for October 31st, 2005, the date Ms. Halbach was murdered, or the subsequent days when her body was burned and the bones were planted. Mr. Hillegas was never asked by law enforcement to provide an alibi for October 31st, 2005. Trial defense counsel failed to conduct any substantive investigation of Mr. Hillegas, choosing to name him as a potential suspect at one point but failing to meet the requirements of Denny. Next slide, please. Mr. Hillegas' cell phone records show significant gaps during the time periods in question. On October 31st, 2005, there was a 6-hour gap, a time frame in which there were neither incoming nor outgoing calls from 9:41 a.m. to 3:48 p.m. It's interesting. It is most likely that during this time frame, Miss Halbach departed the Avery property, departed the Zipperer property, and was killed after she arrived home at approximately 3:40 to 3:50 p.m. Miss Halbach's day planner indicated that she wanted to get Sarah's stuff from Mom at about 3 p.m. and do biz paperwork at approximately 4:30 p.m. Mr. Hillegas' phone records have an over 17-hour gap from 7:47 p.m. on October 31st, 2005 to 1:31 p.m. on November 1st of 2005. During the time where Miss Halbach's body was transported and burned. Subsequently, Mr. Hillegas had more suspicious gaps in calls. Mr. Hillegas had access to Miss Halbach's Singular Wise account and knew her username and password, as evidenced by Mr. Hillegas' admission that he used her username and password to obtain her phone records after she went missing. Next slide, please. Mr. Hillegas called Miss Halbach's phone at 6:42 p.m. on November 1st of 2005. Mr. Hillegas has admitted that when he called on Thursday, November 1st of 2005, an automatic message played saying that Miss Halbach's voicemail box was full. Scratches are visible on the back of Mr. Hillegas' left hand in footage taken prior to the discovery of the RAV4 on November 5th of 2005. Current post-conviction counsel's forensic pathologist Dr. Bloom has opined that Mr. Hillegas' injuries are consistent with scratches from fingernails. The most obvious motive for burning Miss Halbach's body would be if the killer had a known and established relationship with Miss Halbach and his DNA was on her body from a struggle or a rape. Next slide, please. Mr. Hillegas accessed Miss Halbach's voicemail box. After hearing Miss Halbach's voicemail box was full, Mr. Hillegas, who had no trouble accessing Miss Halbach's Singular Wireless account, would be able to delete some of her voicemails in order to prevent family and friends from becoming concerned by a full voicemail box. Miss Halbach's voicemail box had a 20-minute capacity. Singular basic voicemail features attached. When Mr. Avery called Miss Halbach's phone at 4:35 p.m. on October 31st, his phone call went directly to the automated message, which indicated that the voicemail box was full, meaning her voicemail box was occupied by 20 minutes of voicemails, according to Agent Fassbender's report, documenting his receipt of the voicemail records from Singular. 5 minutes and 11 seconds worth of voice messages were left between when Mr. Avery found Miss Halbach's voicemail to be full and when Mr. Pierce found Miss Halbach's voicemail to be full. After Mr. Pierce called around noon on November 2nd, 2005, 3 minutes and 45 seconds of voice messages were recorded to Miss Halbach's voicemail before her voicemail was widely reported to be full on the evening of November 3rd, 2005. So it's like I think that's saying that twice it's almost suggesting that twice voicemail messages were erased, which would make sense.
Yeah, that or that there's two separate sources for concluding how much time was taken off. The one point I'd want to make at this juncture is, a lot of your subscribers, they really dug into this case, and a lot of the things you've been going over, they're familiar with these things because they've established them for themselves. But when you look at the motion, and you have the actual motion in front of you, and you've laid out the paragraphs here, you can go to the motion, and there's paragraph 250, and you've paraphrased it beautifully here. You've summarized it. It's hundreds of pages of materials that you've done a great job of summarizing. But one thing you don't see in the summary is that all of these points, all of these allegations, all of this narrative, she supports. So, for example, 249, she refers to an exhibit, trial testimony, DCI report, Agent Fassbender voicemail report. So these aren't things that she just pulls out of thin air. You can't, you're not going to get anywhere. You didn't get anywhere in the court, but you're not going to get anywhere with an appellate court unless you have the goods to back this up. You have to be able to connect the dots, to a legal standard, not theorize, not speculate, not conjecture. You got to have the goods. And if you're interested, well, how does she come up with that? You can just simply go to the motion, go to paragraph 249. There it is, PC Exhibit 62, trial testimony on February 12th, et cetera, and you can see how she gets there, and you can decide for yourself. I think she's stretching it there, or wow, that makes a lot of sense. I did the same thing and came up with the same conclusion.
Right. Okay. Right. Okay, next slide. Okay, scent tracking dogs showed that Miss Halbach's vehicle was moved onto the Avery property. Scent tracking dogs gave trained alerts in the wooded area south of Cuss Road cul-de-sac and between Mr. Avery's trailer and the Cuss Road cul-de-sac. A human remains detection dog gave a trained alert in the wooded area south of Cuss Road cul-de-sac, where a suspected burial site was discovered. Many dogs converged on this suspected burial site. A shallow ditch had been dug wherein a plastic similar to a tarp was discovered. Sergeant Colborn persuaded everyone it was not a burial site, but no evidence supported that conclusion. Other scent tracking dogs led their handlers through the Redont pit, traveling from the place Miss Halbach's RAV4 was discovered to the Yambo Creek Road. Mr. Hillegas was aware of Sheriff Poggle's intention to conduct aerial surveillance of the Avery property and surrounding properties on November 4th, 2005, to search for Miss Halbach's vehicle. Mr. Kratz admitted that the RAV4 was not visible in the footage taken on November 4th, 2005 aerial surveillance. And he claims that, why? Oh yeah, because a bunch of branches and a big ass hood were leaning up against it, and that wouldn't have stuck out at all. So anyways, next slide please. Okay, the killer parked the RAV4 in the southeast corner of Avery property on a ridge overlooking a pond. The killer returned to the Avery property with Sergeant Colborn in the evening of November 4th, 2005, under the pretense of helping Sergeant Colborn search for Miss Halbach's vehicle. The individual who helped Sergeant Colborn to the RAV4 on the Avery property was most likely the killer, because he was able to enter the Avery property and quickly located the vehicle in the dark or with limited lighting. His words, "It's hers," shouted out when he looked into the vehicle and clearly recognized her personal effects, established that he was a close friend of Miss Halbach. Sergeant Colborn called MCSD dispatch to confirm Miss Halbach's license plate number. But by the time Mr. Avery went to check out the sighting of the headlights, the headlights were off. Mr. Avery called Chuck back at 7:25 p.m. to report he could not see the headlights. The headlights were from Sergeant Colborn's personal vehicle, and he had a friend of Miss Halbach with him to search the Avery property without a search warrant because he did not have probable cause to be on the Avery property at that point in time. Next slide, please. In the days following Miss Halbach's disappearance, Mr. Hillegas spearheaded the citizen search for Miss Halbach. Mr. Hillegas misrepresented his identity when he became the leader of the search. Mr. Hillegas continued to misrepresent his true identity, as evidenced by Wisconsin Department of Justice report of November 16, 2005, in which he is still described as Ryan Kilgus and a very close friend of Teresa's, not an ex-boyfriend, right? Mr. Hillegas made maps for searchers and directed volunteers as to where they should be looking for Miss Halbach. He also made a hand-drawn sketch of his investigation, noting that he found a condom wrapper on the corner of the lot by the first house on Jambo Creek Road. How in the heck would he have any idea that would... Anyway, after Miss Halbach's death, and despite his prior abusive relationship with her, Mr. Hillegas moved into the house shared by Mr. Blodorn and Miss Halbach while the searches were ongoing in order to maintain a tighter control over investigators' access to Miss Halbach's belongings at home. It is reasonable to conclude that he would also have had access to Miss Halbach's sub-key and given it to law enforcement to facilitate the sub-key being planted by Sergeant Colborn and Lieutenant Link. Next slide. In addition to maintaining control over Miss Halbach's home and possessions, Mr. Hillegas personally searched property surrounding the Avery salvage yard and entered the salvage yard on multiple occasions. Even after November 5th, 2005, the police allowed Mr. Hillegas through checkpoints to come and search the area. Mr. Hillegas was not asked to provide an alibi. When asked by police about his last interactions with Miss Halbach, Mr. Hillegas testified that on October 31st, 2005, he dropped something off for Miss Halbach at her house. Suspiciously, Mr. Hillegas does not recall he doesn't recall he delivered to Miss Halbach, nor can he remember anything about what time of day it was. Not day or night. He didn't know if it was dark or light outside. Dude can't remember anything to Miss Halbach's residence, even though this was supposedly the last time when he saw Miss Halbach alive. At first, Mr. Hillegas told law enforcement that he was just a friend of Miss Halbach's. Next slide, please. On the afternoon and evening of November 4th, 2005, Mr. Hillegas received 22 phone calls from a number or numbers with no identifiers. It is reasonable to conclude that the law enforcement officers were calling Mr. Hillegas in connection with conducting an illegal search of the Avery salvage yard, using Mr. Hillegas to access the property. In his pretrial testimony, Mr. Hillegas stated that although he was not sure how many times he talked to Sheriff Poggle on November 4th, 2005, they spoke at least once. Mr. Hillegas did not recall whether he had contact with Investigator Wiegert on November 4th, 2005. Dude doesn't even recognize the lead investigator. Anyway, on November 5th, 2005, with information obtained from law enforcement in 22 unrecorded calls on November 4th, 2005, Mr. Hillegas directed Pam to search Avery's auto salvage. Next slide. Trial defense counsel failed to properly investigate a variety of topics: Colborn's dispatch call, timelines, voicemail deletions, items from Maribel Park, suspected burial site, veracity of the police reports, witness to the RAV4 planting on November 4th. Applicable case law regarding trial defense counsel's duty to investigate. In State v. Thiel, the Wisconsin Supreme Court granted post-conviction relief after the defense attorney at trial failed to conduct a significant investigation. There, the defendant set forth precisely what would have been revealed had the defense attorney conducted an investigation consistent with the defendant's constitutional right to counsel. Next slide, please. Trial defense counsel's failure to investigate and establish the correct timing of Sergeant Colborn's dispatch call and discovery of the RAV4. On November 4th, 2005, Sergeant Colborn discovered Miss Halbach's vehicle and called dispatch on a personal line to confirm Miss Halbach's license plate number. Sergeant Colborn's dispatch call was produced to Trial Defense Counsel, among other calls recorded by the Manitowoc County Sheriff's Department on a CD. The recordings, which are labeled Track 1 through Track 30, give no outward indication of when they were left. Sergeant Colborn's dispatch call was titled Track 3. The preceding recording, Track 2, is a call to Manitowoc Dispatch from an unnamed officer regarding George Zipperer. The officer requested a criminal records check of George Zipperer from that dispatcher. Next slide, please. Sergeant Colborn's explanation that he called MCSD's dispatch to confirm information obtained from Mark Wiegert is contradicted by the chronological order of the Manitowoc County dispatch calls as produced to the Trial Defense Counsel. Sergeant Colborn testified that he placed this call to dispatch after speaking with Investigator Wiegert about Miss Halbach. After departing the MCSD for the Zipperer's property, Sergeant Colborn had no viable reason to call Manitowoc County Dispatch regarding Miss Halbach's vehicle. Further, Sergeant Colborn placed this call from his personal phone, not his squad car's radio. Sergeant Colborn testified that after completing contact with the Zipperers, he checked out the MCSD, which would have included leaving his squad car in the secure MCSD lot, and drove his personal vehicle home. Sergeant Colborn confirmed the identity of Miss Halbach's vehicle by calling MCSD dispatch on his cell phone around 7:30 p.m. on November 4th. Next slide. Trial Defense Counsel's investigators' failure to construct the correct timeline of Miss Halbach's activities on October 31st, 2005. Current post-conviction counsel, using new telephone records of Miss Halbach, has reconstructed the correct timeline and route that Miss Halbach took on October 31st of 2005. At 8:17 a.m., Auto Trader calls Miss Halbach. The duration of this call is 1 minute and 7 seconds. The state omitted this call from its timeline of Miss Halbach's phone activity. 9:46 a.m. Auto Trader called Miss Halbach. The duration of this call was 33 seconds. 11:10 p.m. Auto Trader called Miss Halbach again at 11:10 a.m. for a duration of 5 seconds.
That must be a typo. That's right in the motion, though. You have it correct. Page 122, paragraph 273 says 11:10 p.m. in bold, and then in the body it says 11:10 a.m. I think she just made an error there.
So it should be a.m., right?
Yeah.
Okay. 11:44 a.m. Miss Halbach placed a call to Barb Yonda's landline. Next slide, please. 1:10 p.m. Miss Halbach arrived at Mr. Schmitz's residence. The state incorrectly presented a false timeline to the jury based upon the erroneous recollection of Mr. Schmitz that he received a call from Miss Halbach at 1:10 p.m. Miss Halbach's phone records show that she called Mr. Schmitz at 12:51 p.m. Therefore, contrary to the state's timeline, Miss Halbach arrived 20 minutes earlier at the Schmitz residence than the state represented to the jury. 1:15 p.m. Miss Halbach departed Mr. Schmitz's residence after completing his photographs. Mr. Schmitz testified that Miss Halbach completed his appointment around 1:30 p.m. In light of Mr. Schmitz's mistaken timeline, it is reasonable to conclude that Miss Halbach's departure from Mr. Schmitz's property approximately 20 minutes earlier than what Mr. Schmitz testified at trial. Shortly after 2 p.m., Miss Halbach arrived in the vicinity of the Zipperer residence. Despite searching for approximately 10 minutes, Miss Halbach was unable to locate their house and had decided to proceed to her appointment at the Avery property. Miss Halbach called the Zipperer's landline at 2:12 p.m. to tell them that she was having difficulty finding their house, so she was proceeding to her next appointment and would return. Next slide, please. At 2:24 p.m., Miss Halbach received a call from Mr. Avery, who was wondering where she was and when she would arrive. Miss Halbach did not answer the call. So Stephen Avery, or Mr. Avery, used the star 67 feature on his cell phone so that Miss Halbach would not feel that she needed to return his call if she did not answer, because the star 67 feature would not register Mr. Avery's cell phone number on Miss Halbach's cell phone. At 2:27 p.m., Miss Pliska called Miss Halbach. Miss Pliska's account of her conversation with Miss Halbach is not credible. At trial, Miss Pliska testified that it was Miss Halbach who called her at 2:27 p.m. on October 31st, 2005. Miss Halbach's phone records, as reflected in Mr. Kratz's summary exhibit, show that it was Auto Trader who called Miss Halbach, not vice versa. Trial defense counsel failed to impeach Miss Pliska's testimony effectively that Miss Halbach initiated the 2:27 p.m. call on October 31st. Had trial defense counsel impeached Dawn Pliska, they could have shown that her testimony was not credible about her alleged contact with Miss Halbach, effectively undermining Miss Pliska's testimony that Miss Halbach told her that she was on her way to Avery property at the time of the call. Next slide, please. Between 2:31 and 2:35 p.m., Miss Halbach arrived at the Avery property. Miss Halbach snapped one photograph of Barb's van. Miss Halbach began walking towards Mr. Avery's trailer, but when she saw Mr. Avery come out of his trailer, she waved and turned to go to her car and get his magazine. When Mr. Avery approached the car, Miss Halbach was in the driver's seat with the door open and the engine running. Miss Halbach handed an Auto Trader magazine to Mr. Avery, and he paid her. Miss Halbach turned left onto Highway 147 as she exited the Avery property. At 2:35 p.m., Mr. Avery called Miss Halbach. Because he realized after quickly flipping through the Auto Trader magazine that Auto Trader also advertised front loaders, and Mr. Avery wanted to sell one of his front loaders, Mr. Avery called Miss Halbach at 2:35 p.m. to request that she return to the Avery property to photograph his front loader. He terminated the call before it connected because he wanted to go and see Bobby, but discovered that Bobby was not home. 2:41 p.m. The last voicemail received by Miss Halbach registered to her phone. Miss Halbach was on her way back to the Zipperer residence, based on that fact that the Zipperers had the Auto Trader magazine and receipt. It is clear that Miss Halbach located the Zipperer residence, photographed their vehicle, and departed from the Zipperer residence on November 5th, 2005. Investigator Wiegert and Detective Remacher had a conversation about Miss Halbach's appointment schedule on October 31st, 2005. In that conversation, they discussed their understanding that Zipperer residence was Miss Halbach's final stop on October 31st. That's true. That call is in the dispatch calls. Next slide, please. Trial defense.
Okay, so what we've just gone through is a very detailed timeline that Kathleen Zellner was able to establish through her investigation, obtaining new phone records, and she details it out. So if people are interested, that's on page 122 of the motion, starting at paragraph 273, and then you just went through it, but you included some of the things she cites to, but every one of those times she cites to, in most cases, multiple sources for concluding that something occurred at a particular time. Right. Now, another timeline's coming up here, and I just wanted to point out for everybody. So what we just went through is trial defense counsel's investigators' failure to construct correct timeline for Teresa's activities on 10/31/05. What you're going into now, obviously, is defense counsel's failure to construct an accurate timeline for Mr. Avery's activities on 10/31. So what you just went through, timeline for Teresa, now we're focusing on failing to construct a timeline for Stephen.
Okay. Alrighty. Trial defense counsel's failure to construct an accurate timeline for Mr. Avery's activities on October 31st, 2005. Mr. Avery has given an affidavit that the following is the correct timeline for his activities on October 31st of 2005. At 8:12 a.m., Mr. Avery called Auto Trader to schedule an appointment for his sister Barb Yonda. According to Angela Schuster, manager of the Auto Trader office, Mr. Avery was already linked to Barb's husband Tom Yonda's Auto Trader account. 11:04 a.m., Mr. Avery called Auto Trader from his landline, which was linked to the Auto Trader records to Tom Yonda's account. Let's see. Attached and incorporated herein. Let's see. I'm sorry. Mr. Avery confirmed that a photographer was coming to the Avery property to photograph the Yonda van and that the photographer would be arriving at approximately 2 p.m. Mr. Avery confirmed the address of Barbara Yonda appointment as being 12932 Avery Road. At this point in time, there can be no question that Miss Pliska knew that the appointment scheduled at 8:12 a.m. was made by Mr. Avery and that it was to take place at the Avery property. The state omitted Mr. Avery's call to Auto Trader at 11:04 p.m. from its timeline to the jury. Next slide, please. 2:24 p.m. Mr. Avery called Miss Halbach to see when she would be arriving. Literally, as the phone was ringing, she was pulling in and he hung up. 2:31 p.m. Miss Halbach arrived at the Avery property. Or wait.
That's right.
Well,
PM. Yeah.
No, it's right. It's right. It's just I think he may have called twice. I know he was calling as she pulled in. But anyway, Mr. Avery recalls that when he looked out of his trailer window, he saw Miss Halbach snap one photograph of the Yonda van. Mr. Avery put on his shoes and went outside. Miss Halbach began walking towards Mr. Avery's trailer, but when she saw Mr. Avery, she waved and turned to go to her car and get his magazine. When Mr. Avery approached the car, Miss Halbach was in the driver's seat and the door was open and the engine was running. Mr. Avery approached the driver's door, which Miss Halbach left open, and handed Miss Halbach the cash totaling $40. Miss Halbach handed an Auto Trader magazine to Mr. Avery. Mr. Avery remembers there was no mud splattered on Miss Halbach's car or visible damage to the driver's side bumper or parking light of her vehicle, and the back seats were in the upright position. Miss Halbach turned left onto Highway 147 after leaving the Avery property. 2:35 p.m. Mr. Avery read the Auto Trader advertised for sale of front loaders. He called Miss Halbach to ask her to come back to his property in order to take a picture of a loader that he wished to sell. Mr. Avery hung up before Miss Halbach picked up the phone because he wanted to go see Bobby. Next slide. At 4:35 p.m., Mr. Avery called Miss Halbach again at 4:35 p.m. that evening to set up an appointment for her to photograph the front loader he wanted to advertise in Auto Trader. Mr. Avery's call went to the automated voicemail. 5:36 p.m. Mr. Avery's girlfriend Jody called Mr. Avery from jail. The couple spoke for 15 minutes, the maximum time allowed from jail phones. These calls were recorded by the jail. Around 7 p.m., Mr. Avery had a bonfire. The fire burned for about 2 to 2.5 hours. His nephew Brendan came over as well. They burned brush. 8:57 p.m. Jody called Mr. Avery from jail, the jail phone, and the couple spoke again for a maximum time allowed from the jail phones, which is 15 minutes as from above. This call was recorded by the jail. Brendan went home before Jody called, and by the time Brendan left, the fire had burned down to ash. Next slide. Okay, so that was the timeline according to Stephen, essentially, right? So, trial defense counsel failed to detect the voicemail deletions from Miss Halbach's phone. Miss Halbach owned a Motorola RAV4 in October of 2005. On October 31st, 2005, 6 minutes and 41 seconds worth of voice messages were recorded to Miss Halbach's voicemail. At 8:17 a.m. on October 31st, Auto Trader called Miss Halbach and recorded a 1 minute and 6 second voice message to her mailbox. Next slide, please. Trial defense counsel's failure to investigate and request DNA testing of items recovered from the Maribel Caves Park. A civilian submitted items of potential evidentiary value that were allegedly found at the Maribel Caves on November 6th of 2005 to good old Andy. Good old Andy. Anyways, it's funny how much that guy is involved, and yet there's like less than a half a page from him in case of. Anyway, trial defense counsel failed to investigate the veracity of the police reports regarding Joshua Redant. When Mr. Redant told investigators that he saw a fire on the Avery property on October 31st, 2005, he described the fire as appearing to be contained to a 55-gallon drum. The trial defense counsel failed to investigate Mr. Redant's observation of a fire on the Avery property. Had trial defense counsel investigated Mr. Redant, they would have learned that investigators had pressured Mr. Redant to exaggerate the size of the fire. He refused to do so. No, and we've covered that quite a bit. They kept pressuring him. It was actually agents of the DOJ, folks, and they were pressuring him, like they wanted him to change his account of the fire. So interesting. Next slide.
And where he ultimately said, "Well, you know, what do you want me to tell you?" And I'll say it.
Right.
Well, I just want the truth. And he's like, I've told you 5 times.
Yeah, exactly.
You know, it's not going to change.
That's why he now doesn't talk to anybody without his lawyer there. And then they go over the statement with his lawyer before any. Yeah. So, I mean, that should tell you how fed up he is with the ridiculousness. So, anyway.
And, you know, he had the sophistication and the wherewithal, obviously, to, you know, got a lawyer, and, you know, he's not going to be a pushover. Whereas, you know, 16, 17-year-old boy that they need as, you know, a star witness could be pressured to exaggerate.
Right.
Or, you know, somebody like Scott Tadich, maybe, that is vulnerable in certain areas, they could push and, you know, get flames, you know, from here over, you know, over the roof. But everybody's familiar with that stuff. But you could see here in paragraphs 279, 280, by the time of the motion, it had evolved where she had pretty much eliminated him as a potential Denny suspect, but she lays out why.
Right. Yeah, absolutely. She does a very good job of explaining it in MAM too. Next slide, please. Trial defense counsel's failure to investigate the veracity of the police reports regarding Paul Metz's interview. An example of the reckless investigation by law enforcement in the police report memorializing the interview of Paul Metz, a cattle farmer who lived approximately 4.5 miles north of the Avery property, heard a big whoosh that reminded him of starting a fire with gasoline on November.
A what?
A big whoosh.
A ute? What's a ute? Oh, you said whoosh.
Yeah,
whoosh.
Said whoosh.
What's a whoosh?
A whoosh, like he's him mimicking the sound. Whoosh.
Okay, I thought it was two utes.
Yeah,
Go ahead.
I know what you're talking about, though. I love that part of My Cousin Vinny. Anyway, so it sounded like a fire gasoline on November 1st of 2005. Mr. Metz, in his affidavit, describes a different scenario. The date was October 31st, 2005, not November 1st. As dusk approached, Mr. Metz heard a loud buzzing sound that reminded him of electrical wires surging. Trial defense counsel failed to conduct any investigation of Mr. Metz. Had trial defense counsel investigated the story investigators attributed to Mr. Metz, they would have learned that investigators misrepresented Mr. Metz's detection of a foul odor on October 31st of 2005. So, that's just basically, she's basically saying that everything Paul Metz said happened on November 1st actually happened on October 31st. Next slide. Okay, trial defense counsel failed to investigate the evidence of a possible burial site. Scent tracking dogs as well as human remains detection dogs identified a burial site south of the Cuss Road cul-de-sac, approximately 500 yards west of Mr. Avery's residence. Human remains detection dogs trained to give alerts on decaying human tissue and fluids indicated the presence of human remains at the burial site. Between November 5th and November 8th, 2005, there were numerous opportunities for cadaver and scent dogs to discover the bones in the fire pit of Mr. Avery if they were indeed present there. From the time Mr. Avery left the property early in the morning on November 5th to go to the family cabin up in Crivets. Next slide, please. They searched around the general vicinity of Mr. Avery's residence but did not identify human remains or Miss Halbach's scent. Jill Kramer testified that Brutus was a high-drive cadaver dog, meaning that he is capable of finding very small scent sources from large distances and will persist in working despite inclement weather. Not really true in this case, folks. The sleety rain got to Brutus. Brutus started reacting to other dogs and that sort of stuff. But anyway, Given that Brutus was drawn to the RAV4 from the area of the cars along the elevated ridgeway south of the car crusher, which was approximately 205 feet from the RAV4, it is reasonable to conclude that Brutus was capable of detecting a scent source within a range of at least 200 feet. And I agree. Brutus's prowess when it's perfect conditions, nice sunny clear day, Brutus's prowess is unmatched. Why they waited until conditions that would curb that effectiveness, I have no clue. Anyway, Miss Kramer also testified that Brutus has an extremely low false negative rate and that he very rarely has missed a source during his years as a cadaver dog. On November 6th, sometime between 7:30 a.m. and 12 p.m., another cadaver dog, Trace, was assigned specifically to check the exterior of Mr. Avery's residence, including the driveway and red Plymouth van that Miss Halbach had photographed. Trace identified no human remains on November 7th. Scent and cadaver dogs report. Let's see. Therefore, it is Miss Halbach's remains. Therefore, if Miss Halbach's remains were concentrated in the burn pit on November 5th, when Brutus was searching around Mr. Avery's trailer, it is highly unlikely that he would not alert at that particular site. Next slide, please. Okay, so the cadaver dog alerts on the attached map are as follows. On Miss Halbach's RAV4, where it was discovered. On several spent shell casings along the conveyor road at the southwestern edge of the Avery property. Trial Defense Counsel failed to mention these alerts. The Wisconsin Crime Lab field response team was dispatched to the burial site to take photographs and conduct an examination. However, it was Lieutenant Lincoln Sergeant Colborn along with Sergeant Tyson who performed the evacuation of the burial site and reported that it was of no evidentiary value. Based upon the scent dog's interest in the suspected burial site, it is very probable that Miss Halbach's body was buried at this location for a period of time after her death and before her body was burned. Next slide, please. Trial Defense Counsel's failure to locate and interview witnesses who observed the RAV4 being driven onto the Avery property by the way of the Redant pit prior to November 5th of 2005. William Siebert observed a vehicle similar in color and size to the style of Miss Halbach's RAV4 enter the Redant pit using an access road immediately south of his house. Mr. Siebert's house is immediately north of the east entrance to the Redant pit off of Yambo Creek Road. After observing the vehicle enter the Redant pit, Mr. Siebert saw pictures of Miss Halbach's vehicle on the news. In addition to Mr. Siebert's affidavit witnessing the RAV4 being brought onto the Avery property through the Redant pit, the scent and the cadaver dogs corroborate Mr. Siebert's observations that the RAV4 was brought into the Redant pit from Yambo Creek Road and driven to various places in the Redant pit. The state misrepresented to the jury that it was possible to access the Avery property from the south, where the Redant pit borders the Avery yard. Although Trial Defense Counsel claimed that the Avery property could be accessed through the Redant property, they failed to rely on the dog tracks to corroborate their claim that this is exactly how the vehicle was moved onto the Avery property. Next slide. Okay, once again asking ourselves, why are we here? And today we have a quote. Show me a prisoner whose life has gone stale. I'll show you a young man with so many reasons why. But there but for fortune go you or I, you or I. And that's basically saying, you know, that all these things that we're talking about, folks, it can happen to anybody. It can happen to any of us, you or I, you or I.
If it can happen to him, it can happen to anyone.
Yes, indeed.
And you better believe it.
It's you know, something we all have to remember is constant vigilance. You know, liberty and justice don't just happen. They don't just happen. They require us to care and put in a little work and maintain them. That was a big part of writing the Constitution, and I think it's something that a lot of people have lost touch with, an idea that a lot of people have lost touch with, but it's a big part of how our system works, in that the people get involved and make it work. And it's for the people, by the people. That's the way it's intended. So always remember that. That's why we're here. And I believe that is the end. So just remember, folks, recall your paragraph number, your slide number for your questions. Bring them to the live event, which I'm going to have to say is not going to be tonight, folks. It's going to have to be tomorrow, because by the time I get this thing uploaded, it's going to be about 9 o'clock already, and we're not going to be able to go live tonight after that. So we will see you guys all tomorrow. Get all your questions ready. Get them all noted and whatever. I know KZ's got her Q&A going on tomorrow too, so we'll be able to roll them both into one tomorrow for you, and it should be a nice special event for you. So that's what we're doing. If you haven't already, please hit subscribe, and we'll see you.
Wisconsin can be so cold. The scales of justice can erode. If we accept lies big and bold, we forget we live on Avery Road. We live on Avery Road. Should be easy to see. This could be you, could be me. We shouldn't sit by idly, accepting everything that we are told. I live on Avery Road.